All right, President, case 24CR035, State of Ohio versus David Graves. Mr. Graves was put on community control sanctions to this court back in April of 2024 for a period of 2 years. Motion to terminate those community control sanctions has been filed. We're present for a probable cause hearing. Defendant is here in court. He's with his attorney, Mr. William Watson. Mr. Watson, what's the defendant's intention at this time regarding these hearings he's entitled to?
Thank you, Your Honor. May it please the court, I've had an opportunity to discuss this matter with Mr. Graves, and he is prepared this morning to waive both his probable cause and his final hearing and proceed straight to sentencing, Your Honor.
Thank you. Mr. Graves, you've been charged with violating the conditions of your community. You can be seated. It's easier when you're sitting down. I don't interpret that as any disrespect. You've been charged with violating the conditions of your community control sanctions. It's alleged you violated Rule 3, which requires you to report at such times and places as directed by your probation officer, and it's alleged that you failed to report to your probation officer as scheduled on June 23rd of this year. Now, you have the right to have two hearings regarding this allegation. The first is what we call a probable cause hearing, which is a hearing where the state would be required to present some evidence that would suggest you probably committed this violation. You then have the right to have a final hearing on the merits, and that would be a hearing where the state would be required to prove the actual merits of what they're alleging. Now, you could have either of these hearings, but you can also waive the hearings and plead guilty to the violation, and your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, good morning, Your Honor. Yes, sir.
Good morning. Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you're found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to a total of 5 years. I can impose more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate or end your probation and send you to prison. If I did that, it could be anywhere between 6 to 12 months in prison. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violations, or to the violation, I should say?
I'd like to waive it and plead guilty, Your Honor.
Very well. As the allegation that you violated Rule 3 by failing to report to your probation officer as directed on June 23rd of this year, what is your plea to that?
I just messed up, Your Honor.
No, what is your plea?
Oh, I'll plead guilty, yes, sir.
I'll give you a chance to speak in a second. Very well, the court will accept your plea, find that you did violate your community control sanctions. Mr. Watson, any reason not to proceed to sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. May it please the court. Yeah, I'll be brief. Mr. Graves, for the over a year, about a year, was on probation and apparently doing well, doing everything he was supposed to be doing. During that time period, he picked up a job at a company called Bar Processing. I believe it's in Euclid, Ohio, so right down the street. He polishes steel there. It's a good paying job. He makes $18.50 an hour plus full benefits, medical, dental, paid vacation, with apparently a possibility of joining a union at some point in the future. So it's a pretty solid job. However, he had a hearing, a meeting with his probation officer that was set just generically, because it was the end of each month, was on Memorial Day, And Mr. Graves basically never followed up. I know probation officer was trying to reach him. Mr. Graves told me as much that he should have followed up after that to see his probation officer. He did indicate to me, and I know to probation as well, that June apparently is the anniversary of his mother's death. That's no excuse, but he got a little depressed, and he also admitted freely to smoking marijuana. He did test positive for that. That being said,
I don't think he did yet, but he will probably.
Well, he's admitted it, so if the test is pending, but he's admitted it, Your Honor. So all that being said, Your Honor, Mr. Graves has stood up and has taken full responsibility. He said, you know, I know I should have been more proactive. I know I shouldn't have smoked marijuana. He's not trying to hide anything here. I'm asking the court to take into consideration the fact that he was on probation for about a year with no problems, that he has a solid job, that he can go back to, mind you, he still has it, and give this gentleman one more opportunity at community control, Your Honor, with whatever restrictions the court deems appropriate. I think Mr. Graves has learned a lesson here, Your Honor, and I don't think you're going to see him in front of you again. Thank you.
Thank you. Mr. Graves, you do have the right at this time to say anything you'd like me to know before sentence is imposed. Is there anything you want to say at this time?
Your Honor, I just messed up. I take full responsibility. My phone got messed up, and I just take responsibility. I didn't show up on time.
You didn't show up on time?
I mean, not on time. I didn't show up from but I just like, I've been on track. I've been all my NA meetings. I've been completed all my classes. It's been over a year, and I messed up. I just asked for the court to have leniency on me, and so I don't use my job and stuff like that, Your Honor. That's all.
Tell me about the marijuana use. What happened there? Was it just one time, or was it more than that?
Just one time. I never used it the whole time. I never pissed dirty. It was just my mom died on July 5th, and it was like very depression. That's all.
Oh, it was just last week.
Yeah.
A week and a half ago, whatever. So it was after you failed to appear?
No, it was after. It was like after.
So just last week that you used, or after?
Just like 1, 2.
So that had nothing to do with your failure to appear?
Oh no, it had nothing to do with it.
Then why didn't you show up? Usually, that's the reason people don't show up. They know I thought that's what he said. Maybe I misunderstood that. Usually someone uses, they know they're going to show up, they're going to provide a dirty sample, so they don't show up because they're scared. I don't get why you didn't show up then. You really didn't use before that?
No, I didn't.
Why didn't you show up? That makes no sense.
He had supposed to contact me. I don't know what we got misunderstood.
Yeah, but forget, you're not charged with failing to appear in May. Last time you appeared to probation was in April.
In April, yes.
And then you were supposed to show up on Memorial Day. That would have been, not that you're supposed to show up on Memorial Day, that would have been your normal reporting day.
Yes.
Obviously they're closed. So he was trying to get a hold of you to reschedule that, and that didn't, some reason he couldn't get a hold of you. But he let it go.
Yes.
You're not charged with violating, you're not charged with missing any appointments in May.
Yes.
You're charged with missing an appointment in June, which would be your standard day that you would report in June.
Yes,
So why didn't you show up in June?
I just messed up, that's all. I just messed up.
And it wasn't because you used.
Not because I used it. I ain't been using. I was just like, it just got depressed. I just got depressed that day. My mom was just thinking about my mother, and then that was it. I was coming to show up this Monday. I was going to show up this Monday because I just got a sheet at home, and I was coming Monday though. This Monday.
Today?
Well, today. Today. Yes. I've been here. I've lost the days.
What were you telling? Did you talk to Mr. Graves after he's been arrested?
Yes.
What did he tell you about the marijuana use?
It was at beginning of July.
Oh, I thought you had indicated that's the reason he didn't report.
Oh, no.
Like maybe I just assumed that. You got to keep in touch with your probation officer. You've been doing really well. And I'm not saying you can violate probation, but if you would have, your failure to appear had nothing to do with the marijuana use even. I assumed that was the case. I don't get why you didn't show up.
Probably apologize.
But you made this into a bigger deal than it really would have been. I mean, when someone's doing well, probation's going to work with you, all right?
Yes, sir.
I don't want to tell you, oh, you can screw up because nothing's going to happen. But if you're doing well, they're happy. We're accomplishing what we want to accomplish here.
Yes.
And if something happens, talk to them, and we're going to work with you. Now, if it's something major type of thing, but you still need to talk to them.
Yes, sir.
You dug yourself a bigger hole here than had to be dug.
And I apologize.
Well, don't apologize to me, but you're causing yourself more grief and issues than would have happened if you would have just
Sure.
shown up, if you would have just told them what was going on. I guess I can't figure it out, but is there anything else you'd like to say?
I apologize for not showing up and apologize on the court. You don't have to worry about seeing me no more, Your Honor.
All right, thank you, sir. Mr. Watson, anything else?
No, Your Honor.
Well, the court has considered all the facts and circumstances of the offense involved, the nature of the offense, what's been said here, the defendant's performance on probation, this history of this violation. All this is considered, and the purposes and principles of felony sentencing set forth in 29-2911. I'll incorporate all the findings I've made throughout the case in regards to the the seriousness factors and the recidivism factors, with the additional finding today that the defendant did fail to comply with the previously imposed sanctions ordered by this court. At this time, despite the violation, the court finds that prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm not going to terminate the defendant's community control sanctions. I'm going to extend his community control sanctions by a period of 4 months. I'm going to order that the defendant serve 30 days in jail. He has 5 days of credit. I'll grant you work release privileges. When do you work? Monday through Friday. I'll give you privileges. What are your hours?
8:30, 4:30. 8:30.
8:30 to 4:30 is what he just told me, Your Honor. So
Okay.
if the court
So-
would consider half hour before and after.
Yeah, it's like
Where it's in Euclid?
you
I'll give you 45 minutes. So you're to be released each day at 7:45. 45 minutes should be good enough to get there, right?
Yes, sir.
And to be back by 5:15.
Okay.
All right. I don't want you to lose your job. It sounds like you have a good job. And just keep doing what you were doing. Just report to your probation officer when you're supposed to.
Yes.
Keep doing what you were doing. The other conditions are going to. Oh, do want you to get, when you get out of jail, get a drug and alcohol evaluation. You need to do that right away when you get out of jail.
Okay, sir.
Follow any recommendations that they make for any type of counseling or treatment or whatever they recommend. If they don't recommend anything, fine. But if they recommend some type of relapse program or something, you're going to have to do that.
Okay, sir.
All the other conditions will remain the same. You're not to use any drugs or alcohol, which includes no marijuana. You're to, he completed decision points there?
Yes.
You're to provide random urine screens when requested, 2 AA meetings a week, maintain your full employment, 1 doctor, 1 dentist, 1 pharmacy, pay your court costs and supervision fees. Everything else remains the same.
Yes, sir.
Report when you're supposed to report.
Thank you.
Does the reporting get changed now for a little bit or not?
Your Honor, during work release,
No, not that. I'm talking about, will it be still once a month or will it be twice a month now at the beginning?
It'll be twice a month.
So just make sure you know when you're supposed to report and report when you're supposed to.
Okay, sir.
And it bumped you down there monthly because you were doing well. After a violation, it's going to go back to more than that, and you can earn that back if you're doing well. That's correct, right? Is there anything else, Derek, that I should put on here?
No, Your Honor. Thank you.
So you understand the conditions, Mr. Graves?
Yes, sir.
Any questions for me?
No, sir. Thank you.
All right. I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, another motion will be filed. If it's found that you violated, you could extend your probation up to 5 years, could impose more restrictive sanctions, including more local jail time, or it could end or terminate your probation, send you to prison, and that'd be 12 months in prison consecutive to any other sentence you could be serving at that time or that you're being sentenced to at that time.
Yes, sir.
All right? All right. Good luck.
Thank you,
Want
sir.
anything else?
You have a
Nothing
good day.
further, Your Honor. Thank you.
We are here in two cases of State of Ohio versus Isabella Rotundo. The defendant is present, represented by defense counsel John Fatika. The first case, 25 CR 85, the defendant, it's my understanding the defendant is going to plead to the indictment, which is 2 counts, first count being possession of heroin, second count being possession of a fentanyl-related compound. The other case, case number 25 CR 581, an information was filed with 1 count. That count being possession of a fentanyl-related compound. It's my understanding that the defendant wishes to waive indictment and plead to the information in that case. A motion for intervention was also filed previous to today, and an assessment completed for intervention. The state has no objection.
Thank you. Mr. Fatika, would you like to be heard on your motions?
Yes, Your Honor. It appears from the ILC evaluation as well as the PSR that Ms. Rotundo is eligible, no prior felony convictions. She's testing negative now, taking methadone. She'd like to be in a position where she's no longer taking methadone and continue her treatment. She's working as a server. She has a fairly extensive work history. She's earned her associate's degree. If you look at the sequence here, her father passed away without warning at the age of 46 and 21. Her criminal history, I believe, starts in 22. We'd ask the court to consider ILC here, give her a chance to put these cases behind her and stay clean.
Thank you. Well, Mr. Rotundo, attorney has filed these motions on your behalf. I assume he's discussed these with you and explained what they entail, but I'm going to do that this time. But a motion for intervention in lieu of conviction is a pretty extraordinary request. You're requesting this court to allow you to plead guilty to felony charges, but not find you guilty, not convict you. Instead, put you on a period of rehabilitation and supervision with the probation department where if you successfully complete this program, the charges get dismissed. So like I said, that's a pretty big deal, especially this day and age with attempts to get jobs with felony convictions. It's tough having that on your record, so this is a big request that you're making. In order to be eligible, you meet all the statutory factors, but one of the conditions is a factor that indicates that you are willing to comply with the rules and conditions that are set forth by the court.
Yes, Your Honor.
You able to do that?
Yes,
Willing
Your
to
Honor.
do that?
Yes, sir.
So tell me why you think I should grant this request then.
I would just really like to do better, maintain my sobriety, continue on with things. I would like to utilize my degrees at some point, and like you had mentioned, having a felony and a job is pretty hard, so it would be a really great opportunity that I'd be grateful for if I was able to do this and comply with all the rules, follow everything that I need to do, and understand that there are serious repercussions to actions, and I would just really appreciate it.
So you used to work at NeoCap?
Yes, sir.
What'd you
Yes,
do
Your Honor,
there?
I did. What was that?
What'd you do there?
I was a resident supervisor.
So you know the impact that drugs have on these folks. You saw it every day there.
Absolutely.
Why do you no longer work there?
I ended up leaving there when my father passed away.
So you worked there before that?
Yeah,
Before
I
your
worked there.
father passed?
I worked there before then. He died in 2021 of a heart attack, unexpected. But I had worked there, and I ended up leaving around the time he had passed away. It was just a lot to handle, and I just walked away from it. And then shortly after that is when I started using drugs and alcohol and getting in trouble with the law.
Well, I know these are your first felonies, but there are other convictions here. Are you on probation anywhere right now?
No, I'm not.
What's with the outstanding warrants for the OVI?
They told me it was for animal at large and driving under suspension, and that the OVI was dismissed. But since I didn't show up for a driving under suspension and the animal at large when my dog had gotten out, that they, I don't know how to explain it, kind of like kept that there until it gets taken care of. So,
No, they probably said they were willing to dismiss those charges, maybe. I mean, I don't know. I'm not
right,
part of it,
yes,
but
yes.
You got to show up to court. To
Right.
get that
So
done.
when I had called about it, University Heights and Cleveland Heights, they said if I call them back and schedule a day to come in, that they'll give me a court date.
Why didn't you go
So I just had a baby on June 28th.
in? No. This is
That's the only,
This
I
is
just found out
2024.
about this warrant. I know, I'm sorry. Why didn't I go originally?
yeah.
I was using at the time, I'm sorry.
Okay. Fair enough. How do you feel now?
What was that?
How are you feeling now?
I'm feeling a lot better. You know, I'm feeling better being clean and sober and clear-minded.
So tell me about this ex-boyfriend, Dustin. I know there was issues in Willoughby Municipal Court
Correct.
where you weren't supposed to have contact with him. Now, I know he has nothing to do with these cases,
Right.
so I don't have any, I'm not going to put any orders on, but I understand he's the father of the baby, right?
Yes, and we haven't seen each other since February, I believe. So there really has been no contact. He wasn't there when the child was born. He's not on the birth certificate, anything like that. So I just plan to continue to stay away from
He
him.
hasn't been in touch with you
And
to
do
find
better.
out about what's going on?
He doesn't really care. No.
I mean, I know nothing about him. all
Right, I understand.
I saw a no contact order in here, so I assume there was
Yeah, and that's probably
something
just,
bad.
it was for the best. Yeah, just to stay away from each other. So.
But then obviously, there was at least one time we didn't stay away from each other. There's no relationship there, though?
No, not anymore.
Is he, I mean, I don't know if you know the answer to this. Is he actively using, or you have no idea?
I don't know anything of that. I don't know him to use drugs. I know him. I know he's a criminal, but I don't think
Oh, that wasn't an issue
he
for him?
uses drugs. No, not to my knowledge ever. I mean, people can do anything behind your back,
Sure.
but
All right, well, I've reviewed the statute, the report that was filed. I find the defendant is eligible for intervention of conviction in both of these cases, and I will grant your request. Before I could officially grant it, however, you need to plead guilty to these charges. Assuming that you do that, then I will grant your motion. But before I can accept your guilty plea, I need to make sure you understand what these proceedings are all about, all the rights you're giving up, possible penalties you could face if we ever proceed to sentencing. So I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with Mr. Fatika to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
okay. Thank you,
All
Your
right.
Honor. Thank you.
And let's get started then. How old are you?
I'm 26 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before coming into court here today, have you any drugs or alcohol of any kind?
Prescribed methadone
Is that daily?
every day. Yes, sir.
Any other any other drugs, whether prescribed or not prescribed?
No, Your Honor.
Are you under the influence of the methadone right now in a way that negatively impacts you in any way, that makes it difficult for you to understand or appreciate where you are, what's going on?
No, Your Honor.
Now, in case 25 CR 581, that's the second case, Did you receive a copy of that information that was filed in that case?
Yes, Your
You
Honor.
had a chance to look that over?
Yes.
Now, in that information, you're charged with one count. What's alleged here and what you'll be admitting to is on or about January 9th, 2025, in Willoughby Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. That amount did not equal or exceed 1 gram, which makes the offense possession of a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 of this information?
Yes, Your Honor.
Now, there's also a forfeiture specification that's a part of this that alleges that you possess or had an interest in property considered to be contraband or instrumentality. Excuse me. Contraband is property that's illegal just by the nature of the property itself. It's illegal. Whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner. It's being used to facilitate a crime. You can't possess it or use it for that purpose. In this case, it's alleged specifically that there was powdered substances, plastic cups, and dollar bills. The whole point of this specification is that you forfeit any ownership interest you may have in that property at the time of sentencing. Do you understand that?
Yes, Your Honor.
Any questions about that?
No.
Now, in case 25CR085, that was the first case. That's one that has 2 counts. Did you receive a copy of that indictment?
Yes, Your Honor.
And you read that?
Yes.
In that case, in count 1, what's alleged and what you're admitting to is on or about November 20th, 2024 in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use heroin or some compound mixture, preparation, or substance containing heroin in an amount that did not equal or exceed 1 gram, which makes the offense possession of heroin a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No.
Now, that charge also carries with it a forfeiture specification. The contraband involved in this case is the heroin itself. Do you understand that?
Yes, Your Honor.
Any questions about that?
No.
Now, count 2 alleges on or about November 20th, 2024 in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. The amount did not equal or exceed 1 gram, which makes the offense possession of a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 2 of this indictment?
Yes, Your Honor.
Any questions for me about that?
No.
Now, lastly, there is a forfeiture specification with this count as well, and the instrumentalities involved here is a $2 bill and a debit card. Do you understand that?
Yes, Your Honor.
Forfeit any right you have to that. Do you understand that?
Yes.
All right. So you understand the nature of the charges you're pleading guilty to in both cases?
Yes, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up. And in regards to case 25CR581, that was the second incident. That was at the gas station, right? Or was it a gas station or the first one was a tanning booth?
Tanning bed. The
was
second
the
one was. Oh, I'm
par-
sorry.
Parking lot of the Rebel Cinemas.
Parking, okay. So that's the case we're talking about, the parking lot.
Yes, sir.
You're charged by way of an information. An information is a charge brought by the prosecutor's office without this case having previously been reviewed by a grand jury. Now, at a grand jury, it's made up of a group of citizens here from Lake County that get together and they meet privately in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that a person committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. That, in fact, is what happened in the other case of yours with the tanning bed, where a grand jury reviewed that case and returned this indictment. That didn't happen in the other case, but you have a right to have that happen if you want, where the grand jury can consider the evidence and make the decision. But you can also waive that if you want and go forward on the charge brought by the prosecutor's office without the grand jury having reviewed the case. Your attorney has indicated to the court he believes that's how you want to proceed in this case. Is that correct?
Correct, Your Honor.
Well, before I can go further on this particular case with the information, I need to have you acknowledge that here in open court in writing, and I have in my possession here a one-page document called a waiver of indictment, which sets forth what I've just explained to you about this grand jury process and that you want to give up that right. Before I can go forward, I need to be assured you understand this document, that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review this with your client and answer all our questions?
Yes, Your Honor.
Did she indicate an understanding of it to you?
She did.
Is that correct, Ms. Rotundo?
Yes, Your Honor.
So you understand what the document says?
I do.
Any questions for me?
No.
It also appears you signed the document. Did you sign it?
Yes, I did.
And Mr. Fatika, you witnessed that?
Yes, Your Honor.
Mr. Gretzky, you as well?
Yes, Your Honor.
Very well, then I'll make this document part of the record in that case. At this point, Ms. Rotundo, I'm going to advise you of all the other rights you have that you're giving up by pleading guilty, and these rights apply to both cases. I'm only going to go over them one time, but they apply to both cases, all right? So if you have any questions, make sure you ask. But in each of these two cases, you have the right to have a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, as to each charge in each case, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial in either of these cases, the prosecutor would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it's a criminal case, since both of these are criminal cases, the burden of proof is what we call proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What that actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
I understand, Your Honor,
Do you
yes.
understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, Your
Do you
Honor.
understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses that come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do, it force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right.
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Lastly, if we were to go to trial in either of these cases and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. Now, by pleading guilty here today, you're giving up or waiving any right you have to appeal any issues that you could have raised up until this point, and perhaps a guilty finding if you should later be found guilty of these charges because you didn't comply with the conditions of the intervention plan. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions about any of these rights we've just discussed? These are all the rights you have and all the rights you've given up by pleading guilty. Any questions?
No, I do not, Your
You
Honor.
understand them all?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Now, do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of a guilty plea normally is that you're found guilty of the charges and then you're then sentenced by the court. That's not going to happen here. With treatment in lieu of conviction or intervention in lieu of conviction, the court will accept your guilty plea. I'll then stay all further criminal proceedings, which includes a stay of the sentencing hearing and finding you guilty. I'll put you on a period of supervision under the probation department with an intervention plan with certain conditions and rules to follow. If you follow all those conditions and rules, at the end of that period of time, the case gets dismissed. All the charges get dismissed. If you don't, if there's a violation for not complying with the conditions or rules, then a motion will be filed to terminate your intervention in lieu of conviction. And if it's found that you did violate after a hearing, I would then vacate the stay of criminal proceedings. I'd find you guilty of the charges, and we proceed to sentencing. Obviously, we hope that doesn't happen, and it's not going to happen initially, but I need to make sure you understand the potential penalties you could face if we ever do get to that point. So I'm
Yes.
going to advise you of those potential penalties at this time, all right?
Okay.
And first off, in the first case, 25 CR 085, that's the 2 counts. They're both felonies of the 5th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, in the other case, the 25 CR 581, there's 1 felony of the 5th degree. That also is punishable by a possible term in prison of a minimum of 6 months and a maximum of 12 months. Excuse me, do you understand that?
Yes, Your Honor.
Now, in regards to the first case, since there's 2 charges, if I ever did have to go to sentencing and I imposed a prison sentence, I would impose a prison term on each count. And as a judge, I have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means together. You'd serve them at the same time. Consecutive means one after the other. You'd serve the prison term on count 1, finish that, then the prison term on count 2. You understand the difference there?
Yes, Your Honor.
So in case 25 CR 085, you're looking at a possible maximum prison sentence if we ever proceed to sentencing of 2 years in prison. You understand that?
Yes, Your Honor.
Now, just as I have the discretion to run separate counts in an indictment concurrent or consecutive, I could also run prison terms in different cases concurrent or consecutive. You obviously have 2 cases here, and if we proceed to sentencing in both cases, I could run the prison terms in each case consecutive. So the one case has a 2-year maximum, the other case is a 1-year maximum. If I ran both cases consecutive, with both of these cases here, you're looking at 3 years maximum possible prison sentence. You understand that?
Yes, Your Honor.
I think you answered this question before, but you're not on probation or parole or supervision in any other courts or agencies?
No, I'm not, Your Honor.
You obviously have at least an OVI pending against you, I noticed. Any other charges pending against you anywhere else?
No, Your Honor.
Okay. If a prison sentence were ever ordered with either of these cases, upon your release from prison, you could be placed in what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And for each of these cases, it could be up to 2 years of post-release control. Do you understand that?
Yes, Your Honor.
And if you're on post-release control and you're violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for up to 50% of whatever the maximum, of whatever the penalty is that is imposed by the court. In 25 CR 585, it could be up to 6 months, and the other case with the 2 counts, it could be up to 9 months. Do you understand that maximum?
Yes, Your Honor.
The maximum is 9 months. It can't be more than that.
Yes, Your Honor.
Now, in addition to the possible prison sentence I just mentioned, there's other sanctions that could be ordered, and some that will be ordered, even with intervention or conviction. You will be ordered to pay court costs to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, if we proceed to, and you also will be ordered to forfeit any interest you have in the contraband or instrumentalities I explained to you earlier. Do you understand that?
Yes, Your Honor.
Now, if we proceed to sentencing, I could fine you. I could fine you up to $2,500 on each of these counts. So all three counts together with both cases is a maximum fine of $7,500 that could be ordered. Do you understand that?
Yes, Your Honor.
I could also suspend your driver's license for up to 5 years if we ever proceed with sentencing. Do you understand that?
Yes, Your Honor.
Now, I did explain to you a few moments ago what the possible prison sentence would be if we ever had to proceed to sentencing. I told you it was possible. Prison's not mandatory if we ever had to proceed to sentencing. You would be eligible at that point to be put on probation, or what's called community control sanctions. You'd have the conviction on your record, but you could be put on community control sanctions. You understand, just because you'd be eligible at that point doesn't mean it would be automatic. It means I'll consider everything presented. I'll certainly consider why we're back here again and what led us to having to come back here and all the other circumstances presented to me, and I'll make the decision I think would be the right thing to do. Do you understand that?
Yes, Your Honor.
If you're on community control sanctions, it could be for up to 5 years. As a judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. That could include an order that you serve time in our county jail of up to 6 months. Do you understand that?
Yes, Your Honor.
All right, well, do you understand all the possible penalties you face if we ever did have to proceed to sentencing?
Yes, Your Honor.
Any questions for me about the possible consequences you could face?
No, Your Honor.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have him review the reports with you, discuss the issues, and answer your questions?
Yes, Your Honor. I have.
Are you satisfied with his advice and counsel?
Yes.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the pleas freely and voluntarily?
Yes, Your Honor.
All right then, Ms. Rotundo, do you have any questions for me in regards to either of these cases regarding anything we've just talked about? The possible penalties you face, what you're pleading guilty to, how intervention in lieu of conviction works, any questions at all?
No, I do not, Your Honor.
Do you need any more time to talk to your lawyer?
No, I do not.
Then what's going to happen at this point, the prosecutor will explain for me what she believes the facts would show if we had a trial. We'll do one case at a time. I need you to listen to her because then I'll have some questions for you. So why don't you start with 085, Mrs. Zagretsky. We'll go in chronological order.
Your Honor, in that case, the evidence would show that on November 20th of 2024, the defendant, Isabella Rotundo, overdosed in a tanning bed in Menor, Lake County, Ohio. When police arrived, they were able to open the door to the tanning bedroom in order to get her treatment. Their officers found a bag of white powder under the defendant's phone, and white powder also on the table next to a debit card and a rolled up dollar bill. The seized evidence was sent to Lake County Crime Lab and found to contain heroin and a fentanyl-related compound.
Ms. Rotundo, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we actually did have a trial in this case?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well. Regarding count 1, charging with possession of heroin, felony to the 5th degree with the forfeiture specification, and count 2, charging with possession of fentanyl-related compound, a felony to the 5th degree with the forfeiture specification. How do you plead to each of those 2 counts?
Guilty, Your Honor.
All right. Mr. Gretzky, let's go to the next case, 581, 25-581.
In that case, the evidence would show that on January 9th of 2025, a Willoughby police officer was on patrol, noticed the driver of a running vehicle in the Regal Cinema parking lot in Willoughby, Lake County, Ohio, was slumped over and passed out at the wheel. The officer parked next to the vehicle and confirmed that the female was slumped over and not moving. He opened the passenger door, and that is when the defendant, Isabella Rotundo, woke up. He spoke to her. She was under the influence of narcotics. A search was conducted of the vehicle. The vehicle was found a dollar bill with a white powdery substance, 2 plastic containers with the substance, and in the side door map pocket of the vehicle, 2 separate dollar bills with a white powdery substance. The seized evidence was sent to the Lake County Crime Lab and found to contain a fentanyl-related compound.
Ms. Rotundo, were you able to hear what the prosecutor just had to say regarding what she believes the evidence in this case would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about these facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well. Then regarding count 1 in case 25 CR 581, charging with possession of a fentanyl-related compound, a felony of the 5th degree with the forfeiture specification. What is your plea to that count?
Guilty.
All right, I have in my possession at this time 2 separate documents. Each are called a written plea of guilty and judgment entry, and they basically are pretty much identical except for the specific charges that go along with each case. They set forth everything I've just gone over with you, the rights you're giving up, the penalties you possibly face. Before I can accept your plea, I need to make sure you understand what these documents state and that you sign them here in court. My understanding, again, is before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review these with Ms. Rotundo and answer all our questions?
Yes, Your Honor.
Did she indicate an understanding of these documents to you when you did that?
She did.
Is that correct, Ms. Rotundo?
Yes, Your Honor.
So you understand what the documents state?
Yes.
Any questions from me?
No, Your Honor.
Now, it appears you signed both of these documents. Did you in fact sign each document?
Yes, Your Honor.
And Mr. Fatika, you witnessed that?
Yes, Your Honor, I did.
Mr. Gretzky, you as well?
Yes.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of all those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant, accept the defendant's plea in case 25 CR 085 to count 1, possession of heroin, a felony of the 5th degree, in violation of 292511A with the forfeiture specification. And I won't accept find her guilty. I'll accept her plea to count 2, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of 292511A with the forfeiture specification. And then in case 25 CR 581, I'll accept the defendant's plea of guilty to count 1, possession of a fentanyl-related compound, a felony of the 5th degree, violation of 292511 with the revised code, the forfeiture specification. I will not find the defendant guilty at this time of any of these charges. As I indicated, I will grant the defendant's motion in each case at this point for intervention in lieu of conviction. I'm going to order a stay of all further criminal proceedings in each case. I'm going to place the defendant under the direction and supervision of our Lake County Adult Probation Department in each of these cases for a period of 2 years. And I'm going to implement or order the implementation of the following intervention plan. I'm going to order that you immediately enter and successfully complete an intensive outpatient program through Lake Geauga. I understand you're in this program. I forget the name of it. New Seasons, is that the name of it?
Yes, Your Honor.
New Seasons, which is mainly dealing with the methadone. It doesn't really seem like a treatment program to me. It just seems like they're pushing the methadone. And I want you to get a true IOP program. I understand you still need to, you can't just stop with the methadone.
Right.
But try to wean you off of that. And I understand you want to as well.
Yes.
So when you're at Lake Geauga, when you meet with them, hopefully you're going to meet with their medical team and come up with some plan that you can transfer the medical treatment from New Seasons to Lake Geauga and work on decreasing that and weaning you off of that. That's what the plan here is. And that's what I want you to do. But you're going to, again, complete the IOP through Lake Geauga. You are not to follow all their aftercare recommendations. You're not to use any drugs or alcohol. You have to submit random urine screens. They must be negative. A positive screen's a violation. That includes no marijuana use as well. You're to attend at least 3 AA meetings a week and have a sponsor. Take any and all medications as prescribed and only as prescribed. Only have one doctor and one dentist that could prescribe you medications. If you have a specialist, that's fine as well, but you can only get prescriptions from the doctors whatever doctors you tell probation are prescribing you medication can only get them filled at one pharmacy as well. They need to know where that is. You need to sign any releases that they request so they can talk to those folks if needed. You to pay your court costs and supervision fees. Order the forfeiture of the contraband and instrumentalities in each of the 2 cases. You are to immediately resolve this outstanding warrant that's out there. Is it just one warrant or is there others?
There's one for dog at large as well. I cannot recall.
That's the
if it's
same court though,
warrant.
right? You're telling me that's the same?
I do believe so, yes.
All right, well, whatever there's out there, whatever warrants are out there, you need to resolve those immediately. You can't be on probation or supervision to the court and have warrants out for you.
Yes,
So those
Your
need to
Honor.
get resolved. Mr. Randazzo, anything else that way? Well, I want you to get grief counseling. You talked about that, and that's what everyone's referencing here is started all this. Let's address that. So I want you to get some form of mental health counseling, grief counseling to address those issues. Is that what you're going to say, or was there something else?
Yes, Your Honor.
All right. So, Ms. Rotunda, do you understand all the conditions of the intervention plan?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
Okay, I need to advise you if you fail to comply with any of the conditions that I just imposed, any of the rules that probation will go over with you, you're required to follow the rules of probation as well. If you were to leave Ohio without permission from the court, if you commit another crime going forward, so however you resolve those warrants, if they result in convictions, that's not going to affect this. I'm talking about future crimes from this day forward. If any of that happened, a motion to terminate your intervention in lieu of conviction would be filed. And if it's found that you violated the terms of the plan, at that point I would vacate the stay of criminal proceedings that I just ordered. I'll find you guilty of the charges you just pled guilty to, and we'll proceed to sentencing where any of the penalties that I explained to you just a little bit ago could be ordered, which could include up to 3 years in prison. You understand that?
Yes, Your Honor.
All right. I think that covers everything. Ms. Zagreski, is there anything I missed or need to address?
No, Your Honor.
Mr. Fatika?
No, thank you, Your Honor.
All right, thank you. Good luck.
Thank you.
All rise.
We are here in the case of State of Ohio versus Tyrone Merritt, case number 24-CR-970. Defendant is present in the courtroom represented by defense counsel William Watson. On previous date, the defendant pled guilty to an amended count 1, attempt to commit felonious assault, a felony of the 3rd degree. We are here today for a sentencing in the case.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'm going to be brief. I'm not going to repeat everything we had discussions in chambers about, but my client is a man with, I believe, some anger management issues. And on this day, there was a party, a baby shower, for my client's friend, who was a co-defendant in this case. The co-defendant was the father of this child, and my client went along to this party. And there was some animosity, some friction, some anger between the co-defendant and the mother of the child and the mother's family. And that friction spilled out outside, and my client, who was, I believe, at a moment sitting in a car, lost his temper, got out of the car, ripped his shirt off, and tried to jump into a fight with various people. The victim in this matter, who really had nothing to do with anything, got in between my client and I believe a woman, and there were some other people nearby, and the victim was then punched from behind by the co-defendant. Now that punch, according to a lot of the witnesses that were there, very well may have knocked out the victim in this case. But as he was falling down to the ground, my client then got on top of him and threw his own punch. The victim, as the court I know is well aware, suffered some extremely serious injuries because of this. Was in a coma, and I believe has lifelong injuries as a result of this. My client is extremely remorseful for his conduct that day. He has told me on numerous occasions if he could take back his part in it, that he would. He's really been at a loss of words with regards to what to do or how to handle things. He's taken responsibility for his part in this case while he's been out on bond, and I know this case has dragged on a little longer. I know there was private counsel for a period of time, but during that whole time, he has not picked up any other cases. He was, when this incident happened, he was on probation out of Cuyotta County, but he has successfully completed it. I know the court's aware of that. In fact, I do have a certificate here stating as such that he completed probation out there. He's showing up to every court appearance. He participated with the pre-sentence report. And up until very recently, Your Honor, he was employed full-time. Now, the only reason he left the job, and he left voluntarily, wasn't due to anything bad that he did. He just felt that this was a good job, and he wanted to leave on good terms, and if in fact there was any jail or prison time involved with this sentence, he didn't want to just leave this job hanging. However, they told him that if he does get probation, and you can hear from him in just a moment, but if he does get probation, he's more than welcome back. So technically, he does have a job if the court will consider a community control sanction. I'm going to respectfully ask the court to do just that, consider community control, give my client an opportunity to show this court that he can be a law-abiding citizen. If the court wants to put whatever restrictions on that, I would again maybe suggest anger management classes, but let the court put restrictions on and let my client show the court that he can do what needs to be done, that he can be a good person and he can be a good citizen. I'm respectfully asking the court to give him that opportunity And again, you're going to hear from him just now, Your Honor, but he is extremely remorseful. Thank you, Your Honor.
Thank you. Mr. Mayor, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, sir.
Go ahead.
I want to say, like to Deshaun, I want to apologize to him and let him know that what I did was wrong, and if I could, I'd take it back, and I would go about things differently. And I want to ask the court, can I get probation to show that I can handle probation, and I feel I do need anger management classes, and on that day I lost my cool, and I just want to show that I could be a better man. That's all.
Thank you, sir. Mr. Watson, anything else?
No, Your Honor.
The State of Ohio, Mr. Gretzky?
Thank you, Your Honor. State recommends prison. On that day, the defendant escalated it into a physical fight situation. He took his shirt off, he went on the parking lot and said, "I'll take any one of you," and he stepped towards a woman who was not involved in the fight. And then the victim, her brother, intervened, stepped in front of her. He also had nothing to do with any of the, when I say fight, the argument that preceded all this. The victim was blindsided, punched by the co-defendant here, and on his way down, punched by the defendant. He hit his head on the concrete, and the defendant, co-defendant, and everyone they came with left the scene, left him there. No concern for him. He was in a coma for 3 months. He suffered serious brain injury, multiple fractures. He fractured his, he has facial fractures, and he fractured his teeth, his front teeth as well, and will continue to have injuries or threat of more severe injuries for the rest of his life due to this incident, and he is only in his early 30s. The defendant at the time that this occurred was on probation, and previous to that had been to prison for an offense of violence. For all these reasons, the state believes that prison is the appropriate sentence in this case.
Thank you. This court reviewed the pre-sentence report and investigation. I have considered the facts and circumstances of the offense involved and nature of the offense. I've considered what's been said here in court by Mr. Watson, the defendant himself, prosecutor, the recommendations from the parties. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court notes that the victim in this case suffered serious physical and psychological harm as a result of the conduct. And while the offense itself deals with serious physical harm suffered by the victim and caused by the defendant's conduct in this incident is much more serious than what we normally see in a felonious assault. First of all, a felonious assault could be just getting cut and having a scar, which is considered permanent. But even beyond that, the injuries suffered here were much, much more serious than what we normally have for a felonious assault or an attempted felonious assault. And the victim, as alluded to, suffered serious brain injury. He was in a coma for 3 months. He's still experiencing symptoms and trauma as a result of this incident. He's going to experience seizures perhaps for the rest of his life even as a result of this. Doesn't know when they come on, but they do come on. All because the defendant decided to inject himself into this incident that was occurring that he had nothing to do with even. And the victim in this case was completely innocent. It had nothing to do with whatever was going on that caused this, arguing to take place. And then the defendant gets out of the car, challenges anyone who wants to fight. Steps by near a female, so the victim, steps in front of her, it's his own sister, and then takes the brunt of this beating, or takes this beating. So the conduct itself and the nature of the serious physical harm makes it much more serious than what we normally see for this type of offense. But nothing makes it less serious. As for recidivism factors, the court notes the defendant was on probation at the time he committed this offense to Cuyahoga County. He has a criminal history, which includes a prison term that he served for a robbery charge back in 2010. That's when the conviction was. Served his sentence in 2011 and 12. He's not responded favorably to previously imposed sanctions. No factors indicate recidivism is less likely. It's felony of third degree, so no factor. There's no presumptions one way or the other. Considering the appropriate sentence, there's just no way this court could ignore the extent of the victim's injuries here and what happened to this victim and what he's going to have to experience and suffer for the rest of his life. For nothing. The court finds prisons consistent with the purposes and principles of sentencing, and the defendant's not amenable to available community control sanctions. Therefore, it will be the sentence of this court that on the lesser included offense of count 1, the defendant served a term in prison of 30 months. He has credit for 4 days he's already served. I need to advise you upon your release from prison, you will be placed on post-release control for at least 1 year. Could be up to 3 years. That's up for the parole authority to determine. When on post-release control, if you violate any of their conditions, of their supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Defendant's ordered to pay all costs incurred in this action, and the court hereby releases the bond. Mr. Gretzky, is there anything else for the record?
No, Your Honor. Thank you.
Mr. Watson.
Nothing further, Your Honor.
All rise.
Tyrone, I'm gonna see 2.5 years, 3 months. I'm gonna see you Wednesday, okay? Because you're gonna be in county for just a little bit.
Is that okay?
Stand. Okay.
Yeah, nothing in his pocket, he wants to give too.
But they'll want goat soap, won't they? Make their skin soft. Stan's gonna come over. Huh?
I'm game.
He's gonna come over, he'll play with the goats.
Little goat yoga?
No, when my wife dies and I become the goat man of Perry. And have 400 goats in the middle of a city. And all kinds of crazy yard art in my front yard. What do you think of that?
I can see you doing
When the police come,
that. I got your ID right here.
I'd be like, Wheeler, get off my lawn.
You got a warrant?
You got a warrant? Not? Get the hell out.
All rise. You may be seated.
Thank you, Your Honor. Before you today on State versus James Jones, file 25 CR 413. We're here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence report investigation and is prepared to go forward. Thank you.
Thank you. Mr. Wolf, any reason not to go forward with sentencing?
No, Your Honor. My client and I have also reviewed the pre-sentence investigation, have no changes.
Anything you'd like to say then at this time on behalf of your client?
Thank you, Your Honor. Your Honor, this is James Jones. He's 37 years old. I do submit that he accepts full responsibility and acknowledgement for his conduct in this case. I believe he was very transparent with the PSI author and his statement about what happened in this case. I'm respectfully asking the court to impose a non-residential community control sanction. I recognize the statutory presumption. I recognize his prior record, which exists, albeit relatively minimal. I only say that because he has a juvenile matter when he was 17, and in 2019, he successfully completed an ILC for similar charges out of Geauga County Court. There was a companion case involving a weapons under disability and an improper handling in this case. It has since been nollied by the Lake County Prosecutor's Office. Employment-wise, for the last 5 years, James has been overseeing the operations of an auto detailing facility in Cleveland. They're called Headquarters Auto Spa. This particular auto spa, they also donate to Little League teams, and they do back-to-school drives, and Mr. Jones is very involved with those efforts directly. Educationally, Your Honor, James was previously enrolled in Tri-C. He transferred to Auburn Career Center. His goal was to complete the EMT program. At the time, he wasn't able to graduate due to his juvenile record. Medically, he had a stroke in September of 2024. I do have a bunch of records from the Cleveland Clinic to verify any of this, which I recently received, Your Honor, but I'd submit this stroke was a bit of a catalyst in some respects to this conduct. Without taking away what he did, it sent him in a spiral of depression. When he was approached by this confidential informant, I think he was a little more eager to go along with what was very illegal, which he knew was illegal, but he still has some very real migraine and left side weakness from the stroke that he's dealing with today. He's a father. He has 2 very young children. They're 2 and 3 years old. And despite him sitting here right now, he truly is trying to set a better example for them than what his mother had demonstrated to him when he was growing up. He doesn't know his father. His mother was actively using drugs, and again, despite being here, it is his goal to break the cycle, and he's aware of that. I will submit that he has been involved in treatment, Your Honor. He's currently in the process of an IOP. It's not completed yet. It's with Life Solutions. He was supposed to have negative urine screens during the case of this, so I'm not saying he should be given extra credit for that, but I'm just highlighting he has had negative urine screens during this case. There were a number of letters of support which we submitted. So respectfully, Your Honor, I'd submit that a non-residential community control sanction would be appropriate in this particular case. My analysis of the relevant factors leads me to this conclusion, but I know that Mr. Jones would like to address Your Honor also. So,
Thank you. Mr. Jones, you have the right to address the court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
Yes, sir. I want to start by saying I apologize to you, Judge Vincent, and the person I was that made those irresponsible decisions 6 months ago, or however long it was, is not who I am today. I stand for you. I took the steps to change on my own. I've been doing what I'm supposed to. I've been going, and I'm choked up because
Okay.
it's just put me in like a whole depression state, because the last thing I want to do is not be here for my son like my father wasn't for me. Any time away from him will crush me, and that's not who I am as a person. I'm trying to change on my own. I'm trying to do what's right. I don't want to be away from my kids at all. I took time out, to go to court and regain visitation rights for my daughter, and rebuilding a relationship. And I feel like once I had the stroke, I lost control of everything. I wasn't able to work. I couldn't barely walk. I had to go to treatment as far as like physical therapy and stuff, learning how to talk again. And then I met this woman, and I figured like, oh, well, I could easily just make some money real quick. And as I'm taking the medicine as far as my headaches, I'm smoking weed, and I would just meet her and I would get a little bit of stuff for myself and sprinkle it on the weed, smoke it a little bit, and that'll help me get through how I was living as far as the time period. And the moment I tried to get away from it, it's like she threatened me, like, well, if you don't bring me my stuff, then I'll report your plates. If I sent you this money and you're not here yet, then I'm gonna do X, Y, Z, and I'm gonna make sure you be in trouble. So I was just feeling like this whole situation had happened. It got me away from what I was going through. It almost saved my life. That's exactly how I feel. Like I was spiraling, and at that time I was just spiraling out of control. I didn't know what to do, and she was just like sending me pictures of her naked and asking me to have sex with drugs, all that. And I just was just.
How's the treatment helping you now?
The treatment is helping me big, because it gave me medicine as far as depression go. I'm learning how to cope with depression. I'm learning how to not let things get to me that's bothering me. I'm talking about my problems to somebody that doesn't know me, giving me understanding of what things I need to do as far as getting through life on a day-to-day basis. And again, I apologize to you, Judge. Matter of fact, I want to apologize to my family, anybody that's in this courtroom, because this is not who I am, like, at all. I'm more disappointed in my own self than anything, because I was going on the straight path to get to where I am now. And it's like, now I got to just do a whole 360 and try to just make right of my wrongs and do what's right from this day forward. And that's all I really want to do.
All right, thank you, Mr. Jones. Mr. Wolf, anything else you'd like to add?
No, thank you.
All right, you may be seated. One second, please. Mr. Gregor, for the state of Ohio.
Thank you, Your Honor. State of Ohio entrusts this court to fashion a sentence that's appropriate in this matter, and is aware that there is a presumption for community control sanction. Thank you.
This court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I received numerous letters in support of the defendant. I've read and considered all of those. I've considered what's been said here in court today by Mr. Wolf, the defendant himself, the prosecutor, the recommendations. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. As for the factors in 29-2912, nothing stands out factually to this court indicating the conduct is any more or less serious than what normally constitutes the commission of this offense. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. Gun charge back in 2019. And then while not a conviction, he was involved in conduct very similar to what he's doing here, selling drugs out of Jog County. He did successfully complete intervention in lieu of conviction, so it's not a conviction, but he's engaged in this conduct before his stroke. Nothing indicates recidivism is less likely. There are no factors under 29-2913B1. Considering all the foregoing, the court finds this time the prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. However, Mr. Jones, you knew what you were doing was illegal. I mean, you guys even said it when you were talking here, but there's no question you knew it was illegal. You knew what the consequences would be if you got caught. You knew you would go to jail or even worse, prison if you got caught. You'd be separated from your family, including your children, if you got caught doing it. But you did it anyway. You took that gamble, you took that risk, you lost. And now you want to avoid paying off what your bet. It's like betting on a game and then losing and saying, well, I don't want to pay you. Do I really have to pay you the money? No, that's not how this works. You took that gamble and you lost. And there's going to be consequences for that. You know, looking at this, you even told the gal when she first asked you about heroin that it could kill her. And you went ahead and sold it to her anyway. You knew, and fortunately for you, nothing bad happened. We get cases in here frequently now where people are selling drugs to people and they're overdosing and they're getting charged with manslaughter. That's a risk that you took that you didn't, fortunately for you and whoever and her, didn't come to fruition. But you knew selling drugs is illegal. You knew there's consequences for that and you did it anyway. So the court's going to order that you serve 60 days in the Lake County Jail. You have credit for 2 days. As further conditions, I'm going to order that you enter and successfully complete the jail treatment program, follow all their aftercare recommendations. I'm going to order that you successfully complete the decision point program, follow recommendations. Further conditions, you're not to use any drugs or alcohol. That includes no marijuana. You must submit random urine screens. They have to be negative. A positive screen is a violation. I'm going to order that you attend AA meetings pursuant to the recommendations made by the jail treatment program. Whatever their recommendations are in regards to AA meetings will be conditions of your probation, and you must attend those AA meetings in the amount per week as they recommend, if they recommend any. I want you to obtain and maintain full-time employment. I want you to obtain mental health counseling. Take all medications, if any, as prescribed. Pay court costs and supervision fees. dismiss the remaining counts of the indictment. It counts 2, 4, 2 and 4. Release defendant's bond. Mr. Randallson, is there anything else I should be thinking about or considering here?
We will also need him to sign releases, Your Honor.
I'm sorry?
Sign releases.
For
so
what?
that we can get all of the information from the treatment facility.
Okay, have you sign whatever releases probation needs so they can contact the treatment facilities. So, Mr. Jones, you understand all the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your community control up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your community control and send you to prison. And if I did that, it'd be a period of 12 months on count 1 and 12 months on count 3 to be served consecutive to each other for a period of 24 months. And that would be consecutive to any other prison term you may be serving at that time for some other case, or that you're being sentenced to at that time for some new case. Mr. Geigerich, is there anything else for the record at this time?
No, Your Honor, thank you.
Mr. Wolf.
Thank you, Your Honor. Would Your Honor consider permitting Mr. Jones' work release if we provided a schedule?
He can't do that within the jail treatment program.
Okay.
Thank you.
And then I believe he served a total of 4 days on the arrest from the gun case. I know it was from the gun case stemming from the secret indictment.
That doesn't get credit on this case for that.
Okay, I had to ask, but thank you, Your Honor.
I mean, he hang on one second. Didn't he get arrested on the gun case? He was arrested on the warrant for the secret indictment in this case?
Yes, Your Honor. That was on April 7th.
So what, did he post a bond in this case and then stayed in for 2 more days after that? I guess I'm confused.
I don't know exactly the timeline, Your Honor. Do you want to expound?
I guess my point is, if he got arrested on that day for both cases. He got arrested for this on the secret indictment, and then supposedly for this gun case that got dismissed. So did he get that credit on this case?
My thought was because it was for the secret indictment on the drug case.
There was an indictment that came down?
This case, Your Honor, had the secret indictment.
Right, so he was arrested on this warrant.
Yes.
When he was arrested, it was on this case. So he got that credit.
And you have it as 2 days.
I got that from probation.
Okay.
I mean,
If
that's
I'm
wrong,
sorry for the confusion.
No, I guess I'm saying I don't see how there would be a different time period that he'd have for the gun case than he would on this, since he was arrested on this.
I understand what you're saying.
If it's, well, I can look real quick. We'll make sure. If he thinks it's more, I'll check real fast. You can be seated.
I got arrested. Then I said I had for a little while. Then they came again.
This is showing he was arrested on April 7th. That he bonded out April 8th. So I guess the 7th and the 8th.
I apologize for the confusion, Your Honor. Sorry about that.
Right.
All rise. All rise. You may be seated. Didn't I have a sheet up with you?
Yeah.
Okay, cool. All right.
We're here in case 24 CR 1390. You forgot the 90s, yeah.
Well, there's two cases, 1389,
Yeah, but you just said 13.
Yeah, we left it blank, so we can.
Oh,
There's two
all
cases.
right, strike that. You did the right thing.
Well, I didn't, so I can't take that thing.
All right, we're here in case 24 CR 1389 and 1390. State of Ohio versus Marcel Fialco. We're here for a final hearing in each case. On motions to terminate community control sanctions. Defendant was recently placed on community control sanctions to this court. A motion to terminate those community control sanctions was filed by the state of Ohio, alleging 4 separate violations. Defendant previously waived probable cause, and we're here for the final hearing at this time. Defendant is in court with counsel Mr. William Watson. Mr. Watson, what's the defendant's intention at this time regarding his right to a final hearing?
Thank you, Your Honor. May it please the court, after discussing this matter with my client, he is prepared to waive this afternoon's final hearing and enter plea of guilty to the violations and proceed straight to sentencing, Your Honor.
Thank you. Mr. Fialco, you've been charged with violating the conditions of your community control sanctions. Specifically, there are 4 alleged violations. The first is a Rule 1 violation. Rule 1 requires you to obey all local, state, and federal laws, and it is alleged that on June 10th of this year, you were cited for disorderly conduct while voluntarily intoxicated by the Willowbrook Police Department. Next is a Rule 3 violation, which requires you to report to your probation officer as directed. And it's alleged that on June 12th of this year, you failed to report to your probation department as you were required to do so. The next violation is a Rule 10 violation, which requires you to submit random urine screens when directed and requested by your probation officer. And it's alleged that on June 12th of this year, you failed to submit a urine screen as requested by your probation officer. Lastly, there's another Rule 1 violation, which again requires you to obey all local, state, and federal laws. And this one alleges that on May 27th of this year, you were found guilty of criminal damaging in the Parma Municipal Court for an offense that occurred on May 25th, 2025. Now, you have the right to have a final hearing regarding these allegations, and that is a hearing where the state would be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violation. And your attorney has indicated he believes that's what you want to do, waive the hearing and plead guilty to the violations. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that did occur, in each case, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order that you serve more time in jail, or I could terminate your probation and send you to prison. And if I sent you to prison, in case 24 CR 1390, it would be anywhere from 6 to 12 months in prison. In case 24 CR 1389, it also could be 6 to 12 months in prison. I can also run those sentences in each of those two cases consecutive to each other for a total of 2 years in prison. So that's what you have, that's what you're facing by being found to be a probation violator. Do you understand that?
Yes, Your Honor.
Well, having been advised the potential penalties you face, what would you like to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violation?
I want to waive the hearing and plead guilty to the violation, Your Honor.
Very well, then, as to the first Rule 1 violation for having been cited for disorderly conduct while intoxicated, that was on June 10th of this year. What is your plea to that?
Guilty.
It's just, you're just admitting to that fact that you were cited for it. You're not admitting to the violation itself. You're not admitting to the disorderly conduct. That still has to be resolved in municipal court, but you're pleading guilty to being cited for that.
Yes, Your Honor.
Okay. Your plea's guilty to that?
Yes, Your Honor.
As for the Rule 3 violation for failing to report to your probation officer on June 12th, what is your plea to that?
Guilty, Your Honor.
As for the Rule 10 violation for failing to provide a urine screen as directed by your probation officer on June 12th, what is your plea to that?
Guilty, Your Honor.
And as to the second Rule 1 violation for having been convicted of a new offense being criminal damaging in the Parma Municipal Court on May 27th of this year, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, Mr. Fialco is a troubled young man, Your Honor, and I believe he has not only mental health problems, but he has substance abuse problems, and I think all of that is compounded even further with his current housing situation, which is he's homeless. That's certainly not an excuse for picking up these new cases, but I think it goes to show the court that Mr. Fialco is spiraling out of control on his own. I think personally that he would benefit from a more structured environment. I know certainly that prison's an option and that may be structured, but I don't think that's going to address his underlying issues, Your Honor. And I know the court gave my office some time to work on this, but and just today the court was provided that Mr. Fialco was accepted to the B. Riley institution. It is there where he will stay at a minimum of 30 days for a residential inpatient program, could be longer. And then after that, as the court is aware, they have halfway houses and three-quarter-way houses, which I think will go a long way to help Mr. Fialco, giving him a stable place to live, a roof over his head, and maybe, hopefully, while he's there, he's also able then to address his mental health issues and his substance abuse issues. So I think this is a good opportunity for Mr. Fialco. I know the court has a lot of discretion today as to what direction it can go, but I'm hoping it will consider placing him into the B. Riley Institute and allowing him to continue on probation and hopefully get the help that he needs. Thank you, Your Honor.
Mr. Fialco, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
I think it's a good opportunity for me to get help
What's a good opportunity for you to get help?
at the B. Riley house.
What's going on here? You were just sentenced by me not even 3 months ago. You didn't get out of jail until less than 2 months ago. 2 months ago, maybe like today, any day now. I've never had someone come back with so many violations in such a quick time. You've committed a new offense literally a few days later after you got out in Parma. Got another new offense pending. You're using, you're not reporting. What's going on here? I mean, this doesn't look like this is going to be successful.
I was in here. That's what the new offense is for. I was in here, so I couldn't report to probation.
Sorry?
I was in here, so I couldn't report to
Where
probation.
were you?
in jail,
What jail were you
in Lake County.
in? On June 12th?
No, for the Parma, for the May 10th.
I'm not following you.
For the June 12th, I couldn't make it there.
Why not?
I had called to tell them about the citation. I had transportation for my appointment, but I didn't have transportation to the appointment because I was out in Willowick.
Well, then probation's not going to work if you're not going to be able to get where you're set to get to.
I will be able to get there.
Sorry?
I will be able to get there.
Well, what were you talking about? You were in jail.
I was talking about the probation violation for Parma.
Okay, what about that one?
I had an appointment the 26th that I couldn't make it to.
You're not charged with You're not charged with missing probation when you were in the Parma jail. The violation dealing with you failing to report is on June 12th, is it? June 10th or 12th? I can't remember exactly. June 12th.
I was talking about the Rule 1 violation.
For committing a new offense when you were committing a new offense for the conviction in Parma?
Yes, Your Honor.
You're saying you didn't do that?
I'm saying I was in here. That's why I couldn't go to my appointment.
I'm confused.
Originally, I thought you were talking about that and not the June 12th. Sorry, Your Honor.
The only violation that you are charged with for not reporting to your probation officers for June 12th. You're not accused of failing to report on any other day.
Okay, Your Honor. Sorry, Your Honor.
Oh, you're saying you missed some time in May, but that was because you were in Parma? You didn't report in May because you were in the Parma jail?
Yes, Your Honor.
You may have been, but you're not, we didn't